Okay. Hello, YouTube, America, whomever. Just letting you know this is entertainment. It's not legal advice. I stated yesterday in my rant that some some things that I felt like I needed to go over and show proof of, so that people don't think that I'm just running off at the mouth without any facts to back it up. It's a lot of information, so I'm going to get started on it. Try to go through this as quickly as possible. If you need to, stop the video, read what I've got, because I'm going to kind of skip through some of it, but a lot of information here. So anyway, jurisdiction is the power and authority constitutionally conferred on a court or judge to pronounce a sentence of law. Law, you understand? Provided by law on a statement of facts proved or admitted to and authorized by law to be the subject of the investigation or action, and in favor or against persons who present themselves. Now, that's a key term right there. When you present yourself, you are subjecting yourself to their authority. You become the subject. All of it has to be sanctioned by law, though. So if they're going to tell you, hey, you got to come in, it's okay for them to tell you that. But once you walk in there, then you've admitted that they have authority over you, and you've just given up all your rights. So, moving on. Plainly declares the court or administrative action must have subject matter jurisdiction. That's 28 U.S.C. 1738b C1a. Substantive law is that part of the law which the courts are established to administer, as opposed to rules. Standing is the right of the people to challenge the conduct of another person. Let's see. Valley Forge Christian College versus American United for Separation of Church and State. Limitation includes requirement that the plaintiff have standing to bring the action. Requires that the plaintiff personally has suffered some actual or threatened injury. Okay, Hollingsworth v. Perry. The litigant must seek remedy for a personal and tangible harm. All this is going to come back to you in the end. I'm going to try to get back to all of this, but this is just letting you know that they only have authority if they're standing. They can only have subject matter jurisdiction if the plaintiff has standing. That's all going to come back. Lujan versus Defenders of Wildlife means that a plaintiff, case controversy requirement of Article 3 in the Constitution means that a plaintiff must have suffered an injury in fact. The defendant's conduct must have caused the injury, and there must be some likelihood that a court could provide a remedy for the harm. Government regulations of a third party generally do not give rise to a concrete injury that can support standing. That third party is going to come back too. The harm is not concrete or imminent, and the law does not provide standing for every citizen based on generalized grievances. That's going to come back too, because it's speculation, conjectural, hypothetical. I'll get to all that. Congress could not provide such standing under Article 3 since standing requirements may not be constitutionally avoided. That's key right there. It cannot be avoided. It must have standing. Standing is particularly difficult to show here since third parties, rather than the respondents, are the object of the government action. Respondents did not demonstrate they have suffered an injury in fact. They failed to show that one or more of the members would thereby be directly affected. All this is going to come back. Over the years, our cases have established the irreducible constitutional minimum of standing contains 3 elements. Plaintiff must have suffered an injury in fact or an invasion of a legally protected interest, which is concrete and particularized. and actual or imminent, not conjectural or hypothetical. There must be causal connection. In other words, your conduct must have caused some injury between the injury and the conduct complained of. The injury has to be fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party not before the court. This all comes back. It must be likely as opposed to merely speculative that the injury will be redressed by a favorable decision. That's key right there, speculative. See, when you go in there and they take your money and they say that it's going to benefit your child, that's speculation. They don't know that. I mean, your ex could be hooked on whatever and spending the money like a wild woman. You don't know that she's going to take better care of your kids. They can't prove that. It's speculation. A legally protected interest is something more than an economic interest. It is one which the substantive law recognizes as belonging to or being owned by the applicant. See, that's key too. It has to be owned by the applicant. It cannot be a third party. It is an interest that derives from a legal right. The 11th Circuit has in no uncertain terms excluded this definition, purely economic interest. So it can be purely economic interest as long as it's direct effect of your causal conduct. But see, danum absque injuria, that means loss, such as loss of funds, loss of money, loss of food, whatever, without an injury in the legal sense, without such an invasion of rights which is redressable by an action of the court, a loss which does not give rise to an action of damages. That's exactly what child support is. It doesn't give rise. You didn't do any injury. Probable cause, facts and evidences that lead many to believe the accused actually committed the crime. Well, you know, right there, Title 42, 601B, there is no individual entitlement, and it shall not be interpreted to entitle any individual or family to assistance under a state program. So they're telling you right there's no individual entitlement, cannot be a third party, and it has to be directly. It has to be direct. It doesn't create any enforceable right. Thank Amon Osiris for this one. We Hunt v. Ledbetter. Coercion means any plan or scheme intended to cause a person to believe that failure to perform an act would result in physical restraint, such as being locked up for failure to pay, or the abuse or threatened abuse of the legal process. See, abuse of the legal process is simply using the legal process for something which it is not intended. In other words, if there is no injury in fact and no proof of fault that you caused that injury, then they're abusing the legal process because that's not what it was intended for. Diversity of jurisdiction does not include power to determine support obligations. The reason for that is because they ain't proved an injury. And Florida statutes even go further. They tell you straight up that they have no authority until after the issuance of the order. 88-2051, the tribunal issuing order that has issued. So that's after the fact. And then they shall have continuing exclusive jurisdiction. But that's all after the fact. It even states it right here in 6113(1)(a)(2). The court initially entering an order requiring one or both parents to make child support payments as continuing jurisdiction after entry of the initial order. Now, an administrative regulation, of course, is not a statute. They are at most but offsprings of statutes. Where rights are secured by the Constitution, Miranda v. Arizona, there can be no rulemaking or legislation which would abrogate them. Arbitrary, in other words, you're going to do what we say because we say so. Color of authority. That presumption of authority sustaining acts of a public officer which is derived from his apparent title to the office or from a writ or other process in his hands apparently valid and regular. See, apparently still means presumption. Just because somebody's sitting on a goddamn bench doesn't mean that they have authority over you. Just because you're in a rented courtroom, which it is a rented courtroom, look it up. It's open meetings, Title 5 USC 552B. Straight out, it's open meetings. There's no such thing as a child support court on the administrative side. There are two divisions. I can show you that right here.